Yes, it is true that in the past 1 week there has been a lot of concern raised through both social media and mainstream media about the impending expiry of letters of administration. But what I like about the topic that I was given is that it broadly talked about the key amendments that were introduced to the Succession Act. And like I have always said, succession law falls under personal law. That's why it affects people directly, regardless of status in society. From a peasant even up to the head of or the first citizen, all people are subject to this succession. It is important, therefore, to know that the amendments were many, and I'll eventually zero down on the expiry, but it is important that the general public knows that a raft of changes were made to the succession laws, which many people may not know about, and we don't want that to be clouded by just only the expiry, because in about 2005, some women activists petitioned the Constitutional Court to declare some provisions of the Succession Act unconstitutional. But key among those provisions was Section 27 then, which provided for shares in an estate. So law advocacy for women versus Attorney General in the Constitutional Court. And specifically they were saying that the share that was given to surviving spouses when they lose their husband or wife, which is 15% of the estate, was discriminatory and unconstitutional. And they were saying 15% did not, for example, take into account polygamous families, which are very prevalent in the Ugandan society. Because under polygamy, it means a man can, for example, marry even 20 women under polygamous or customary marriage. So if we had 20 women, all of them were supposed to share the 15%, which could become negligible, actually. So amongst other sections of the Succession Act, the Constitutional Court indeed declared that section of 27 as unconstitutional. But when the Uganda Law Reform Commission now undertook to revise the Succession Act, it decided to take a broader look, not only those provisions that were before the Constitutional Court. Because as you know, succession law being sensitive, just like the Marriage Act, we all know that the Marriage Act has been in Parliament for over 50 years. These are not very easily amendable laws because of obvious reasons that I've stated. It has a lot of personal and emotions usually. You have seen what happens in Parliament whenever the marriage bill comes to the floor. You all know what happens. And it has failed to take off. So it is little wonder that even the Succession Act took 50 years to amend the Succession Act, because it was last amended in 1972, then in 2022, those are 50 years. So they are not easily amended because of emotions. I always give this example that, for example, you can amend the Trademark Act in Parliament and no one will actually know, apart from people who are in that field of maybe trademarks. Even some lawyers may not know about it. But if you touch the Land Act, everybody will know about it. And everybody will have an opinion about the Land Act.
Are you a woman with a small-scale business with a dream of growing it to another level? The GROW Project is here to support you in realizing your dream.
The GROW Project is a government initiative implemented by the Ministry of Gender, Labour and Social Development and Private Sector Foundation Uganda with support from the World Bank.
We support women-owned businesses across the country to gain hands-on and business management skills through training within your location, business financing through grants and affordable loans, and infrastructure in your areas of operation to enable you to increase your productivity.
If you have a business that makes sales of up to 800,000 Uganda shillings per month, the GROW Project has the tools and resources to help you succeed. For more information, contact your district or city GROW focal person or call our toll-free line on 0800 307 777 to learn more about how you can benefit from the GROW Project's services.
The GROW Project, empowering women economically, transforming communities.
So, the Succession Act now took, the Uganda Law Reform Commission took a broader approach and amended a number of provisions in the Succession Act, eventually. For example, we had a contentious issue on stepsons and stepdaughters. And the old act was defining a child to include a stepson or a stepdaughter. And a good example would be, for example, if a woman comes to get married, but she comes, let's say, with a child who is not of that, who doesn't belong to the man, but she comes with a child. And the issue is that when the man dies, if the woman came with a child 1 year old and he has grown up in that family as if a child of that man, the succession law was implying that that child would benefit from that estate. So during this amendment, there was a lot of emotions about it, but eventually they deleted any reference to a stepson or a stepdaughter. And as we talk now, those people cannot benefit from an estate of a deceased person. They removed terms such as illegitimate children because the Succession Act still was talking of illegitimate children. And yet, under our Ugandan society, even case law has established that there is nothing like an illegitimate child. Most families have these children, and at times they are looked at as if they are different from the children of the marriage. So, for example, a married couple has 5 children, and then maybe a man has a child from outside that marriage. They used to be termed illegitimate, and that is English law because in England, for them, they have those illegitimate children if you are born out of wedlock, and then they also have mistresses and so on and so forth. So our law, having emanated from England, we had those terms as illegitimate. But in the Ugandan society, that is not the case. So they removed any reference to illegitimate children. In that, I'm just briefly mentioning the key amendments. Of course, the issue of the heir or heir, customary heir, the Succession Act has given an impression that only men or boys could be heirs. And especially some cultures, actually, you can't talk to them about a girl being a customary heiress. It is almost unheard of in some societies in Uganda. And I think you all remember a prominent person died, a former prime minister of this country. He died and left a will where he named his daughter as a hairless, prominent Muganda man, and you all heard the noise from Mengo, that not at all. How can a girl be a hairless? And they have their own cultural justifications. And it makes sense a little bit, but it is discriminatory under the current constitutional dispensation. So now, the succession amendment made it clear that even girls can be heiresses. The other was on dependent relative, which at times is of course confused for a dependent, because in Uganda, to benefit from an estate of somebody who has died, a dependent relative, the person you should have been dependent on the deceased, but also related to the deceased. So that's why it is dependent relative and not dependent, because dependent is so broad, it can even mean somebody who was not related to you, whom you picked from the street and you were looking after. But the law is restricting it to dependent relative. In other words, you should be related to the deceased by blood, either a nephew, a niece, uncle, sister, whatever. There must be blood. But also previously, for that person to qualify, the law is saying that you are supposed to be substantially dependent on the deceased. Substantially, not wholly. Now the amendment changes the whole thing and says you must be wholly dependent on the deceased in order for you to claim a share as a dependent relative. So then there were changes that were made on a will, especially on the signing of a will and witnessing it. That provision that there must be signing of all pages of the will. It is good practice, even if it was not to be embedded in the law, that your will is signed on all pages to avoid issues of.
Are you a woman with a small-scale business with a dream of growing it to another level? The GROW Project is here to support you in realizing your dream.
The GROW Project is a government initiative implemented by the Ministry of Gender, Labour and Social Development and Private Sector Foundation Uganda with support from the World Bank.
We support women-owned businesses across the country to gain hands-on and business management skills through training within your location, business financing through grants and affordable loans, and infrastructure in your areas of operation to enable you to increase your productivity.
If you have a business that makes sales of up to 800,000 Uganda shillings per month, the GROW Project has the tools and resources to help you succeed. For more information, contact your district or city GROW focal person or call our toll-free line on 0800 307 777 to learn more about how you can benefit from the GROW Project's services.
The GROW Project, empowering women economically, transforming communities.
Yes, because it was possible that a man can have children outside wedlock, and it is rampant. And usually those children are discovered after the death, in most cases. And yet our law doesn't discriminate children, that these are from a married, from the marriage, and then these ones are from outside, and there's no distinction between the children. So the issue of a woman automatically applying was amended slightly. Because if you say that a married woman can just go directly to court, the fear is that she may not cater for the interests of children who are not hers. So to avoid that, they said that now a widow can also be vetted by the Administrator General. In other words, you come to the Office of Administrator General and we do thorough investigations to find out, did the deceased have children with you alone, even if you are legally married to him. And in most cases, those children come up during those investigative meetings. And once they come up, we then now have to to have administration, maybe joint administration, to cater for those children who are not from the legal marriage. So that is also a very important aspect of the amendment. Of course, the other was to change or revise the percentages. Previously, the widow was getting 15%. The women activists and women parliamentarians had suggested that a woman or a wife or the surviving spouse should get 50% of the estate, but that was declined by Parliament, and they said the surviving spouse should only get 20%. The children remained at 75%. Dependent relatives get 4%, and then the customary heir gets 1%. Then the other issue that was also quite contentious was what happens when, for example, a woman remarries after the death of the husband, and does she still get a share if she remarries? Because the law doesn't stop a woman, for example, or a widow from remarrying after the death of the husband. She's free, and the man is also free to get another wife. The wife is free to get another man upon death. But the issue is that if she remarries, can she come back during the distribution of the estate and say, yes, I want my share? And after debate in Parliament, which was also heated, they agreed that yes, she should come back and get her 20%. Why? Why would you? Because the marriage was ended by death. So she's entitled to 20%, and she's also entitled to remarry. So the issue is that she can still come back and get her 20%. The other was now on separation, because, and it happens a lot, that a man dies, but at the time he dies, they had separated with the woman. It is a very common occurrence, because after the death, the women or woman usually comes back. So at the time of death, they have separated, they are living apart. But after the death, she comes or he comes back. Usually it is she, because she's the one who moves out of the home, and there's that separation. So the law was that when you have separated from the person, you are not entitled to a share when that man dies. And that is still the principle, that separation for 2 years, for example, prior to death of the man, then you are not entitled to a share. And the law is only giving an exception, for example, where you had gone for study. They call it the approved course of study. That if you were on a study leave, yes, that is understandable. But Parliament introduced other exceptions. For example, the wife had left the home, but the person who caused the separation is the man. So the woman didn't go or didn't separate on her own. She was forced to separate because of the man. So the man caused the separation. So the Parliament just brought in some exceptions. Or the man is the one who has left the home, and that happens a lot. So these days it is not a woman leaving the home, which is now physical separation and going elsewhere, but the men also leave women in the home and they go away. So he has a home in Endeavour with his wife, and then he abandons the home and goes and stays in Mukono. Now there is a separation, but now the law is saying, she has to benefit from your estate because you are the one who went away. It is not her fault that there was separation. So it is a very, those are very dicey issues of personal issues that the amendment touched on. And then maybe finally was on the home, saying that a home where the deceased was staying should not be subject to distribution, because previously people would, when a man dies, the home is sold off. And that is especially where a man has left the home as maybe the only property, or it is the most prime property. And it happens a lot. For example, when a man is just beginning in life, he has a modest home with his first wife. Usually it is modest. Then as he grows up and accumulates wealth and gets wealthier, men, not all of them, but some men, decide to take on another younger woman. And usually that younger woman, now let's say the man was the first marriage in 1990, the home might be somewhere in the village. And usually the younger one now gets a home somewhere in town which is more prime. So, serious war erupts there after the death. The family in Gomba, when it hears that there is another home in Muyenga, they used to say, yes, all this is property of our father. We are all entitled. So they would invite, they would say, the Muyenga people, if you want, you are also free to come and stay here in Gomba. And we are also free, those of Gomba, to go and stay in Muyenga. And when it came to distribution, they would say, let's sell. Let's put these things in a pool, we sell and we share. So there was that lacuna, and the Parliament had to come in and say, no. When a man dies and he has many homes, stay where you are at the time of death. Don't start now saying, but now I need, we are also entitled to that Kololo mansion. Stay where you are to avoid confusion. Very contentious, because some people come and say, but for us, he was renting for us. I mean, he was just paying, renting in Iwaise for us. And yet there is a very comfortable home in Muyenga or elsewhere. Why should we suffer? Very contentious issue, practically. The law is there, but practically some of us who deal with these things face a lot of issues. Now, back now to the one that has caused the excitement, the one on expire of letters of administration. As you all know, previously when people got letters of administration, the whole country was in a slumber. Administrators have letters of administration, but some of them even don't know that they have letters of administration. They got letters of administration in 1990, for example, and he has even forgotten that he got letters of administration. So he even has no copy. There is one who came to office and I told him, you go to the family division and they check for you, and they discovered indeed he was granted letters of administration in 1992. And he had not done anything with the estate. He had even misplaced the letters of administration. There are people with the letters of administration of 1975. Because as you know, the Succession Act starts applying to Ugandans in 1972. So, people have letters of administration, but they have never done anything. Or they are doing things wrongly. Taking on properties, not distributing to the entitled beneficiaries, And therefore Parliament was of the view that, first of all, we need to awaken the sleeping administrators. So to me, actually, while people are doing this, for me, you see the law is working now. Because people are awakened from sleep. The concerns you are hearing is that now people are awakened from sleep. It's like when you are sleeping and then somebody comes and pours cold water on you. That is what the intention was. So now the issue is, if you have letters of administration issued in 1980, so today is now 40, those are 45 years. There is a need for you to come and tell court, what have you done in the 45 years? What do the beneficiaries say? Have you been a good administrator? That's why they're saying extended, but with the consent of the beneficiaries. So the beneficiaries have to tell us, in the 45 years, what has this man or woman done? Are you happy with it? You'll be shocked. The stories that are going to come up. So Parliament said, one, because it gave different timelines, 3 of them. So 31st May 2022. That is the date when the amendment comes into effect. So it is a very important date for us to understand all these other periods that we are going to talk about. So they are saying that any letters of administration granted before 31st May 2022 were given 3 years. 3 years to expire. 3 years from when? From 31st May 2022, meaning expire 31st May 2025. So any grant issued in the 70s, in the 80s, in the 90s, in the 2000s, those categories. And in the 2000s up to 31st May 2022 were given 3 years to expire. So that is the first category, and those are the ones that many people are concerned about, because there are many. There are in their thousands, so many actually. Now the second category are those now that were issued after the amendment. So after 31st May 2022, courts issued the letters of administration from that date. Now those ones after the amendment had come into force were given 2 years. So those ones have already been expired, and actually people have been applying and extending them. So those ones should not cause a lot of alarm, because I know and I have seen very many that people have extended. Those are 31st May 2022 up to now. And with them, the courts even indicate the exact expiry date. So if you get, for example, today is the 22nd May 2025, the court will indicate on the letters that this letter will expire on the 22nd of May 2027. So that is the second category. The third category, which is also very important because it involves again the general public, but people are not talking about it much, are letters of administration issued to the Administrator General. Now, Administrator General also has letters of administration on estates issued by court. Some people, some families even don't know that Administrator General has letters on their estates, especially the grandchildren and so on and so forth. So it is only when they come to process them, and then we say, but Administrator General got letters in 1990. But people were in slumber, they were not following up their interests. So the Administrator General, for him, unlike private persons who were given 3 years, The Administrator General for him was given 5 years. The letters of administration issued to the Administrator General before 31st May 2022 are going to expire on 31st May 2027. So any family that has Administrator General as the administrator of the estate, and there are so many, where our letters will expire in 2027, 31st May 2027. So, these categories, Parliament put a remedy of extension. So it is not doom and gloom like it was being stated in various social media and mainstream media, as if people are going to lose property, as if people somehow there's a crisis. No, the law provides for extension of letters of administration. And even when they have expired, because some judges have actually said that you can't apply for extension when it is still running. So to extend what? So it is after expiry, you have to go to court and give justification why the period should be extended. Very important, because administrators, much as they are trustees, administrators thought that they are the owners of property. There was that misconception. When an administrator gets letters of administration, they think that they are owners of the property. And some beneficiaries have never benefited from their father's estate because administrators think that it is their property. So it is important that when they give you power, you should come back to court and tell court why you need more time. And the beneficiaries should tell court that yes, we have no problem with him. Actually, he just has issues with court cases, he has issues with this, but as an administrator, he has done well. The beneficiaries must give a consent before they extend those letters. So, those people, after 31st May, all administrators in Uganda, you are supposed to account, because many have not accounted for the properties they have managed for the last 40, 30, 20 years. Why should we extend it? But the law has also provided for exceptions. For example, where the estate is receiving pension. If your father, for example, was a civil servant, and let's say a police officer, and is entitled to pension, usually they pay for a long period, pension, about 15 years, depending on how they have calculated it. So those letters only expire after you people have finished receiving the pension. So that is also something that did not come out clearly and was causing alarm. Estates receiving pension, since pension takes time, the letters will not expire until the pension is exhausted. And then also estates where the beneficiaries are below 18 years and the guardian has got letters of administration. Let's say guardian gets a letter of administration on an estate of children below 18, let's say 10 years. If it is 10 years, the law is saying that the letters of administration will only terminate upon the children acquiring majority age. So if somebody is 10 years, then it means the letters of administration will continue for 8 years and then terminate when a child attains 18 years of age. So it is not doom and gloom. It was an awakening measure that administrators are deep asleep. Some of them don't know that they even have letters. Some of them know but they are doing wrong things, so they don't want to account. Then some of them are just ignorant about their roles, and therefore this awakens them and sets straight the record for administration of estates. So briefly, that is what I wanted to go through with the key amendments, the Succession Act, and then specifically on expiry of letters of administration. I thank you.